Welcome to one of the most disturbing cases recorded in the history of Montgomery, Alabama. Before we begin, I invite you to leave in the comments where you're watching from and the exact time you're listening to this narration. We're interested in knowing which places and times of day or night these documented accounts reach. In the early hours of March 15, 1845, as a fierce thunderstorm battered the windows of Ashford Hall, Magistrate Cornelius Ashford summoned 3 witnesses to his bedside and dictated a last will and testament that would tear apart the legal establishment of Alabama for the next 7 years. The document, sealed with red wax and witnessed by a notary, 2 prominent attorneys, and the family physician, declared that Daniel, a 28-year-old man who according to property records was legally owned by the magistrate, would inherit everything. 900 acres of prime cotton land, the 3-story federal mansion with its columned portico, investments valued at $47,000, and most impossibly under Alabama law, his freedom. What makes this case particularly haunting is not simply that a magistrate violated the very laws he had sworn to uphold, but what investigators discovered when they opened the sealed codicil that Ashford had insisted could only be read after his burial. Inside was a confession written in the magistrate's own trembling hand, admitting that Daniel was not property he had acquired, but a son he had fathered with an enslaved woman named Sarah who had died bringing him into the world. For 28 years, Cornelius Ashford had presided over a courtroom, dispensing justice and interpreting law, while living with the knowledge that he had enslaved his own child to protect his reputation in Montgomery society. Cornelius Ashford was born in 1789 in Richmond, Virginia, the youngest son of a merchant family of modest means. According to biographical records preserved in the Virginia Historical Society, he studied law through apprenticeship with a Richmond attorney and was admitted to the bar in 1811. By 1815, seeking greater opportunities, he had relocated to the Alabama Territory, settling in what would become Montgomery County just as the region was being opened to large-scale cotton cultivation. Tax records from the Alabama Department of Archives and History show Ashford's steady accumulation of wealth and property throughout the 1820s. He purchased his first enslaved workers in 1818, acquired the land that would become Ashford Hall in 1822, and by 1825 had established himself sufficiently in local society to be appointed as a magistrate, a position he would hold continuously until his death 20 years later. The magistrate's court in antebellum Alabama held significant power. According to legal historian Dr. Margaret Whitfield, whose 1967 study of Alabama jurisprudence examined Ashford's career in detail, magistrates had jurisdiction over civil disputes, minor criminal cases, and significantly, matters involving enslaved people. They issued passes for movement, heard cases of theft or assault, and made rulings on property disputes when that property happened to be human beings. Ashford's judicial record, preserved in the Montgomery County Courthouse archives, reveals a man respected for his legal acumen but noted for unusual patterns in his rulings. Of the 247 cases involving enslaved persons that came before his court between 1825 and 1845, Ashford ruled in ways that contemporaries found surprisingly lenient. He routinely minimized punishments, granted travel passes more freely than other magistrates, and in several documented cases, ruled that enslaved persons had been treated with excessive cruelty. A letter from fellow magistrate William Harrison to a colleague in Mobile, dated November 1837 and discovered in 1962, expressed puzzlement at Ashford's judicial temperament. Cornelius displays a peculiar sympathy in cases involving Negro property that I cannot quite fathom, Harrison wrote. Yesterday he ruled that Jenkins could not sell a family separately, claiming it would constitute unnecessary cruelty. When I questioned him privately, he became quite agitated and suggested that perhaps our laws do not account for all dimensions of justice. What Harrison and others in Montgomery society did not know was that in 1816, just a year after arriving in Alabama, Ashford had formed a relationship with Sarah, a young enslaved woman owned by a neighboring planter. According to records discovered in 1958 during a courthouse renovation, in 1817, Ashford purchased Sarah from her owner for the then substantial sum of $800, considerably more than the typical price. Sarah was installed at Ashford Hall, where according to sparse documentation available, she served as housekeeper and managed the domestic staff. The arrangement appeared unremarkable to outside observers. What was hidden from public view was the nature of their relationship and what would come of it. On February 12, 1817, according to a birth record kept in Ashford's private papers and discovered in 1973, Sarah gave birth to a son. The child was delivered by Dr. Thomas Melbourne, the same physician who would witness Ashford's midnight will 28 years later. Complications during the birth proved fatal to Sarah, who died within hours. The infant was named Daniel. According to a notation in Ashford's journal, this was Sarah's final request. What Ashford did next reveals the terrible moral calculus of a man trapped between law and conscience. Rather than freeing the child or acknowledging paternity, Ashford chose a third path. He registered Daniel as his property, inherited from Sarah, and raised the boy within the household as enslaved. However, the documentary evidence suggests that Daniel's enslavement was unlike that of others on the plantation. According to testimony of household staff collected in depositions during the 1850s legal battles, Daniel was never assigned field work. He lived in the main house rather than the quarters. Most significantly, Ashford personally taught him to read, write, and calculate, violations of Alabama law that carried substantial penalties. Margaret Ellis, who worked as a cook at Ashford Hall from 1835 to 1847, provided detailed testimony in 1851 about the unusual relationship. The master treated Daniel different from the start, she stated in a deposition preserved in circuit court records. Daniel ate at table with the master when no guests were present. He had his own room in the main house. The master spent hours teaching him from books in the library. We all knew something was different, but nobody dared speak of it. Another household servant, Jacob Thompson, testified that he had observed the magistrate watching Daniel with an expression he described as equal parts pride and agony. There was times I'd see the master just staring at Daniel, his face showing such pain. Once I heard him talking to himself in the library, saying, "What have I done? What have I made him?" But whenever company came, he'd call Daniel boy, and order him about like any other servant. As Daniel grew into adulthood, the contradictions of his position became increasingly apparent. By the early 1840s, according to plantation records, he was effectively managing Ashford Hall's operations, maintaining accounts, corresponding with cotton buyers, and overseeing other workers. Yet legally, he remained property himself, unable to own anything, unable to move freely, unable to marry, and subject to sale at his owner's whim. The question that haunted subsequent investigations was how much Daniel understood about his true relationship to Ashford. According to testimony from Dr. Melbourne given during probate proceedings in 1846, the physician believed Daniel had suspected the truth for years. The resemblance was remarkable, Melbourne stated. Same build, same features, same mannerisms. I cannot believe the young man was unaware, though we never spoke of it directly. What triggered Ashford's decision to finally acknowledge the truth remains partially mysterious. The most significant clue comes from his personal journal, a leather-bound volume discovered in 1973 behind a false panel in his study. The journal, covering the years 1840 to 1845, reveals a man in escalating psychological torment. An entry from June 1842 reads, "Today I sat in court and ruled on a case involving the sale of a boy, aged 12, separated from his mother against her desperate pleas. I ruled according to law, which permitted the transaction. But as I rendered judgment, I caught Daniel's eye. The look he gave me held such knowledge, such quiet accusation. Does he know? Has he always known? I am a magistrate who enforces laws that justify the enslavement of my own son. What manner of man does that make me?" Later entries show Ashford beginning to research legal precedents, searching for any pathway that might allow him to free Daniel and provide for him after his death. He corresponded with attorneys in northern states, inquiring about the validity of wills executed in one jurisdiction but meant to take effect in another. He studied manumission laws from other southern states, looking for loopholes. And most significantly, he began preparing elaborate legal arguments to defend the will he knew would be challenged. The entries from late 1844 reveal that Ashford had been diagnosed with heart disease by Dr. Melbourne and knew his time was limited. "I have perhaps a year remaining," he wrote in November 1844. "I have spent 27 years as a coward, protecting my reputation while denying my son his birthright. I will not die a coward. If I cannot live with honor, perhaps I can at least die attempting it. What Ashford did next demonstrated remarkable legal sophistication. He drafted not one will, but two. The first, the official will that would be read publicly, contained the declaration freeing Daniel and naming him sole heir. But Ashford knew this will would immediately be challenged as illegal under Alabama law. The second will, the one discovered only in 1973, was never witnessed or notarized. Instead, it served as a detailed legal brief, arguing why the first will should be considered valid despite Alabama statutes. This document, which ran to 47 handwritten pages, demonstrated Ashford's decades of legal experience applied to the most personal case he would ever argue, even if posthumously. In this secret will, Ashford constructed elaborate arguments based on constitutional principles, natural law theory, and legal precedents from other jurisdictions. Most significantly, the secret will contained a section in which Ashford admitted his paternity and argued that natural law gave a father the right to provide for his offspring regardless of legal classification. I have studied law for 34 years, he wrote. I have enforced laws I found unjust because I believed in the rule of law. But I now understand that some laws are so fundamentally evil that they have no moral force. A law that would allow me to enslave my own son is such a law. On the night of March 14, 1845, Magistrate Ashford's condition deteriorated rapidly. According to Dr. Melbourne's medical notes, the magistrate suffered a severe cardiac episode around 10 in the evening. Knowing death was imminent, Ashford summoned the witnesses he had previously arranged. Melbourne himself, two attorneys named Samuel Worthington and James Crawford, and a notary public, Harrison Mitchell. The scene that unfolded in Ashford's bedchamber in the early hours of March 15 was described in later testimony by all four witnesses. Ashford, propped up in bed and struggling to breathe, dictated his will clearly and deliberately despite his physical distress. The attorneys attempted several times to dissuade him, warning that the will would certainly be challenged. Ashford's response, recorded in the notary's account, was firm. Then let it be challenged. Let my reasoning be examined. Let a court for once consider whether the laws we have made serve justice or merely serve those who benefit from injustice. I am beyond caring for my reputation. I care only that before I face whatever judgment awaits me, I will have done one honest thing in 28 years of dishonor. The will was completed, signed, and witnessed at 2:47 in the morning, according to the timestamp on the notarial seal. Ashford then requested that Daniel be summoned. What passed between father and son in those final moments was witnessed only by Dr. Melbourne, who recorded in his journal. The magistrate took Daniel's hand and spoke to him privately for perhaps 10 minutes. I could not hear the words, but I saw Daniel's face transform from confusion to shock to something I can only describe as anguished understanding. Tears fell from both men's faces. When the magistrate finished speaking, Daniel said only, "I know, sir. I have always known." They remained holding hands until the magistrate expired at 3:20 a.m. Cornelius Ashford was buried 3 days later in the family plot at Oakwood Cemetery in Montgomery. The funeral was well attended by members of the local legal establishment and prominent citizens. The eulogy praised Ashford's years of judicial service, making no mention of the will or its contents, which at that point were known only to the witnesses. The reading of the will took place the following week. Present were Daniel, the executors, and representatives of the Alabama Attorney General's office. When the contents were revealed, the reaction was immediate and explosive. The state's representatives declared the will void as it violated at least 3 separate Alabama statutes. Daniel, they argued, had no legal capacity to inherit as he was not legally a person but property. Daniel, however, had resources that enslaved persons typically lacked. Ashford had arranged for his defense to be handled by Worthington and Crawford, two of Alabama's most skilled attorneys, with fees prepaid from the estate. Moreover, Ashford had transferred significant funds several years earlier to a trust in Philadelphia, to be used exclusively for Daniel's legal defense. The case that followed, formally titled Estate of Cornelius Ashford versus State of Alabama, became one of the most closely watched legal battles in the antebellum South. It wound through Alabama courts from 1845 to 1852, generating hundreds of pages of legal arguments and establishing precedents that would be cited in civil rights cases more than a century later. The core legal question was deceptively simple. Could a will simultaneously free a person and make that person an heir? Worthington and Crawford argued that the law should interpret wills to carry out the testator's intent when possible. Ashford's intent was clear: to free Daniel and provide for him. If the law permitted each action separately, then logic demanded it permit them in combination. The state's attorneys countered that this interpretation would effectively nullify Alabama's restrictions on inheritance by enslaved persons. Any slaveholder could circumvent the law by simply including manumission as the first clause of a will before naming that person as heir. The case reached the Circuit Court of Montgomery County in September 1846. Judge William Patterson, in a ruling that surprised many observers, found partially in Daniel's favor. Patterson ruled that the manumission provision was valid. However, he held that at the moment of Ashford's death, Daniel was still legally enslaved, and therefore could not inherit. The estate would pass to Ashford's cousin, but Daniel would be free. Neither side was satisfied. Both appealed. The case moved to the Alabama Supreme Court in 1848. It was during this period that the sealed codicil to Ashford's will was finally opened, as the magistrate's instructions specified it should only be read if the case reached the state's highest court. When the confession of paternity was revealed, it added an entirely new dimension to the legal battle and created a sensation throughout Alabama. Newspapers from Mobile to Huntsville covered the revelations extensively. The disclosure of Daniel's paternity fundamentally changed the legal landscape. Worthington and Crawford filed amended arguments introducing novel legal theories. They cited Roman law concepts, English common law traditions, and most controversially, argued that Alabama's slave codes created constitutional violations. These arguments forced the Alabama Supreme Court to grapple with questions that threatened the entire legal structure of slavery. If a free man had legal obligations to his biological children regardless of their mother's status, did that not imply that enslaved persons had some measure of natural rights? If paternity created claims that transcended property law, how could the institution of chattel slavery be maintained? The court's deliberations lasted nearly 2 years. During this time, Daniel lived in strange legal limbo. Judge Patterson's lower court ruling meant he was technically free, but unable to inherit or access the estate's resources. He remained at Ashford Hall, now as a hired manager rather than as property or owner. The Alabama Supreme Court issued its ruling on February 3, 1852, in a complex and deeply divided opinion. Chief Justice Abner Lipscomb, writing for a narrow 3-2 majority, upheld Judge Patterson's manumission ruling but went further, allowing Daniel to inherit a substantial portion, though not all, of the estate. Lipscomb acknowledged that normally, Alabama law did not permit inheritance by enslaved persons. However, he argued that when testamentary manumission and testamentary inheritance were combined in a single document, the legal fiction should be that the freed person's status changed instantaneously at the moment of the testator's death, making them capable of receiving the inheritance. However, Lipscomb also held that Alabama's public policy concerns meant that the full inheritance could not be honored. Daniel would receive 1/3 of the estate's value, with the remainder passing to Ashford's Virginia cousin. This compromise honored the testator's primary intent while limiting the precedent's impact. The two dissenting justices issued vigorous dissent arguing that the majority had effectively rewritten Alabama's slave code from the bench. Justice Samuel Rice wrote that the decision created a dangerous precedent. More fundamentally, Rice argued that acknowledging Daniel's inheritance claim implicitly recognized that enslaved persons had some measure of legal personhood beyond their status as property, a recognition that could undermine the entire legal foundation of slavery. Despite the partial nature of his victory, Daniel emerged from the 7-year legal battle as a relatively wealthy free man. The 1/3 of the estate he inherited amounted to approximately $15,000 in cash and investments, plus 300 acres of Ashford Hall's original plantation. How Daniel chose to use this inheritance provides insight into his character. Rather than leaving Alabama immediately, Daniel remained at Ashford Hall. He hired free laborers rather than purchasing enslaved workers. According to newspaper accounts from the period, Daniel also used his resources to quietly purchase and free several enslaved families, often reuniting relatives who had been separated. Daniel's decision to take Ashford's surname was itself significant. Under Alabama law, free people of color were required to register with county authorities. Daniel officially registered as Daniel Ashford, explicitly claiming the familial connection his father had denied in life. Perhaps the most revealing insight into Daniel's character comes from his decision regarding Cornelius Ashford's grave. In 1853, Daniel commissioned a new headstone to replace the simple marker at his father's burial. The inscription Daniel chose would become the subject of much discussion in Montgomery society. The stone, which remains in Oakwood Cemetery today, reads, Cornelius Ashford, 1789 to 1845. Magistrate. Master. Father. May God grant him the mercy he struggled to grant himself. Erected by his son, Daniel Ashford, that truth might be remembered when comfortable lies are preferred. The inscription's stark honesty violated the conventions of memorial language. Several prominent citizens reportedly pressured Daniel to remove or modify the stone. According to a letter from Daniel to Worthington dated May 1853, discovered in family papers in 1982, Daniel refused. The stone speaks truth, he wrote. It names our relationship, which he could not name in life. And it ensures that anyone visiting his grave must confront the contradiction he embodied. The outbreak of the Civil War in 1861 created new dangers for Daniel. Alabama seceded in January 1861, and as the war progressed, free people of color faced increasing hostility and restrictions. In 1862, according to records discovered in Canadian archives in 1994, Daniel made the decision to leave Alabama. He sold his remaining interest in Ashford Hall, liquidated his investments, and arranged passage north. By fall 1862, Daniel had reached Montreal. Daniel lived in Montreal for the next 34 years. According to census records, he never married and had no children. He worked as a clerk and bookkeeper, maintained a quiet life, and rarely spoke of his background. However, he maintained correspondence with the Worthington family, through which historians have tracked his life. In these letters, Daniel occasionally reflected on his experiences. In a letter dated November 1875, Daniel wrote, I have had 30 years to consider Magistrate Ashford's actions. I cannot forgive him for raising me as property when he had power to raise me as a son. Yet I also cannot dismiss the courage it took for him to finally acknowledge truth, even if only at death's door. What manner of man does that? A complicated one, neither villain nor hero, but deeply, painfully human. Daniel Ashford died in Montreal on March 15, 1896, exactly 51 years to the day after his father's death and the midnight will. His death certificate listed his occupation as accountant and his birthplace as Alabama. He was buried in Montreal's Mount Royal Cemetery under a simple stone bearing only his name and dates. In his own will, Daniel left his modest estate to organizations working to assist formerly enslaved people during Reconstruction. However, he reserved a small sum to maintain both his grave in Montreal and his father's grave in Montgomery, ensuring neither would fall into disrepair. This final gesture of filial duty toward a man who had simultaneously been father and master encapsulates the moral complexity of their relationship. The story might have faded into obscurity if not for discoveries made during courthouse renovations in 1973. Workers removed wall paneling in what had been Magistrate Ashford's chambers and discovered a hidden compartment. Inside was a metal document box containing Ashford's private papers, including the 47-page secret will, his journal from 1840 to 1845, and letters between Ashford and Sarah from before Daniel's birth. Dr. Jennifer Whitmore, who studied the documents for her doctoral dissertation at the University of Alabama in 1978, described them as one of the most complete records we possess of the inner life of someone caught between the role of slaveholder and the reality of human connection that the system was designed to deny. The letters between Ashford and Sarah revealed genuine affection, though the profound power imbalance cannot be discounted. In one letter dated October 1816, Sarah wrote, "You speak of future plans, but we both know there is no future that includes both of us in the way you imagine. I am your property before I am anything else. If there is a child, as I believe there may be, what will become of him or her? That is the question that keeps me wakeful. This letter confirms Sarah was aware of her pregnancy shortly before her death and had already begun to worry about the child's fate. Her question hung over Daniel's entire life. What will become of him? The 1973 discovery sparked renewed academic interest in the Ashford case. Legal scholars recognized it as an important precedent in American property law and the gradual recognition of personhood for enslaved people. In 1985, the Alabama State Bar Association commissioned a historical marker for the old Montgomery County Courthouse. The marker's text reads, "In this courthouse, Magistrate Cornelius Ashford, 1789 to 1845, presided over cases for 20 years. At his death, his will freed Daniel, an enslaved man who was his son, and named him heir, leading to a landmark Alabama Supreme Court case, 1852, that expanded the legal rights of freed people." The physical remnants of the Ashford story are few. Ashford Hall burned in 1867, leaving only foundations. The property was subdivided and developed. Today, a historical marker on a suburban Montgomery street identifies the approximate location. The gravestones of both Cornelius and Daniel, however, remain. Cornelius's stone in Montgomery's Oakwood Cemetery, with its uncomfortably honest inscription, continues to provoke thought among visitors. Cemetery records indicate the stone has been vandalized twice, once in 1954 and once in 1968, with portions chiseled away, but on both occasions restored using Daniel's endowment funds. Yet the most enduring presence of the Ashford story may be in the realm of the unexplained. Local legend holds that on certain nights, particularly those with storms similar to the one that raged on the night of Ashford's death, a light can be seen moving from the old courthouse site to Oakwood Cemetery, as if someone is carrying a lantern along the route between the magistrate's office and his home. Those who have reported seeing the light describe it with remarkable consistency, a steady yellow-white glow that moves purposefully along a specific path, pausing at certain points as if someone carrying it has stopped to rest, then continuing until it reaches the area where Ashford is buried, where it lingers before fading away. More frequently reported are experiences of profound unease among visitors to Ashford's grave, particularly lawyers and judges. Multiple attorneys have reported, in interviews conducted by researchers, a sensation of being judged themselves while standing before the stone, as if Ashford's ghost still presides over a courtroom, but now with perfect knowledge of his own failings. One Montgomery attorney, speaking anonymously in a 1992 oral history project, described his experience. "I went to Oakwood to see Ashford's grave after reading about the case in law school. When I found the stone and read the inscription, I felt this overwhelming sense of being watched, of being evaluated. I remember thinking, what would I have done in his position? Would I have had the courage to violate unjust laws even at the end? I left feeling that I had been found wanting by some invisible jury." Whether these experiences reflect genuine supernatural phenomena or the psychological weight of confronting profound moral questions, they speak to the enduring power of the Ashford story to disturb and challenge those who encounter it. The case continues to be taught in law schools as an example of how personal circumstances can collide with legal structures. It appears in histories of slavery and emancipation as an illustration of complex human realities behind legal abstractions. And it serves as a reminder that the stories we find most difficult to categorize are often the ones most worth remembering. Perhaps the most fitting epitaph for both men comes not from their gravestones but from Daniel's final letter to the Worthington family, written just months before his death in 1896. "My father gave me the worst thing imaginable, the experience of being owned by someone who loved me. And he gave me the best thing possible, the means to be free and the understanding that freedom is worth any cost. I spent 28 years as property and 51 years as a man. The first made the second precious beyond measure. If his ghost walks, as some in Montgomery claim, perhaps it walks because he knows that justice and love sometimes require us to destroy the very systems we helped build, even if we can only find the courage at the final hour."